Ready, start. Since the respondent advocate was not representing the complainant or his predecessor Devji Parmar, there was no justification behind his arraignment in the complaint for alleged misconduct within the meaning of Section 35 of the 1961 Act. We say so for the reason that there existed no professional relationship between the respondent advocate and the complainant. His prosecution as being the lawyer of the opposite party in the suit before the High Court was highly objectionable, totally impermissible, and absolutely uncalled for. Ordinarily, the existence of a jural relationship between the complainant and the advocate concerned is a precondition for the invocation of disciplinary jurisdiction on the ground of double inverted comma professional misconduct double inverted comma close. We are of the considered opinion that even if the respondent advocate had actually represented and pleaded the case of the plaintiff Messrs. Unique Construction in the suit and had not merely identified the plaintiff, that act in isolation could not be termed as misconduct within the meaning of Section 35 of the 1961 Act because the acts attributed to the advocate taken on their face value cannot be regarded as misconduct, professional or otherwise. The scheme of Section 35 of the 1961 Act exposits that where a complaint is received from the State Bar Council, it must record its reasons to believe that any advocate on its role has been guilty of professional or other misconduct, and only thereafter can the matter be referred for disposal to the DC. Thus, recording of reasons to believe that the advocate has committed misconduct is a sine qua non before the complaint can be referred to the disciplinary committee for inquiry. The order passed supra by the judge advocate referring the complaint to the DC is absolutely cryptic and laconic, for it does not record any satisfaction to the effect that the respondent advocate had committed misconduct as provided under Section 35 of the 1961 Act. The order dated 6th July 2023 does not even make a bald reference to the gist of allegations as set out in the complaint, and hence the same suffers from total non-application of mind. Reference of a complaint of the DC would have serious consequences on the professional career of the lawyer and could tarnish his image and standing in the profession. Hence, a cryptic order referring the complaint to the DC without a bare minimum discussion of the allegations contained in the complaint would not satisfy the requirements of a valid reference order. In the absence of such prima facie satisfaction, the statutory requirement under Section 35 remains non-complied, and the order of reference is ex facie in teeth of Section 35 within bracket 1 of the 1961 Act. Hence, the same cannot be sustained. Resultantly, the complaint number 27 of 2023 filed by the complainant before BCMG and all proceedings sought to be undertaken are hereby quashed and set aside. The pending writ petition before the High Court shall stand closed. Cost of rupees 50,000 is imposed on the appellant BCMG for entertaining the frivolous complaint and for dragging the respondent advocate to this court.